Donna Tope. I'm here on behalf of the plaintiffs, Alec Jerome and Caroline Jerome.
Welcome to Trial Truth, where courtroom reality is more dramatic than television fiction. Today's case, a legal tangle that blurs the line between professionalism and personal involvement. We've got landlords, tenants, counterclaims, and even an attorney accused of crossing ethical boundaries. The courtroom is tense. Judge Simpson's tone says it all. This isn't a small rent dispute. This is a test of integrity. As the session opens, each attorney steps forward to establish authority. You can almost feel the underlying tension as names are read. Jerome, Cassidy, University of Michigan Legal Services. It's a collision of property law, tenant rights, and professional ethics. The moment the judge calls the first order of business, the air stiffens. He's hinting that something serious is on the table. A motion to disqualify counsel. That's no procedural hiccup. It's a bomb. Imagine being told mid-case that your lawyer might not even be allowed to represent you. Would you panic, or would you stand your ground?
Okay.
They are here by Zoom.
Yes, I do see that.
Good afternoon, Your Honor. Francie Novar appearing on behalf of Eric Cassidy. Gail Rosen from the University of Michigan Student Legal Services has filed an appearance on behalf of Paula Cassidy. However, Ms. Rosen is at a conference this week, and so we are proceeding without her presence.
All right. I think the first order of business that we have to take up is before it goes any further, is the motion, I think, filed by Ms. Rosen. So I don't know, counsel, if you were going to, well, who was going to argue that motion? She's not here.
I'm fine arguing the motion, Your Honor.
All right. And counsel, you received a copy of the motion?
By email.
Okay. I did not get a response to the motion, but
I haven't had a chance to respond, but I will today.
okay.
Your Honor, I did also mail the motion on Monday and email it as well.
All right. Well, without here, I've reviewed the motion and I don't need much argument unless somebody wants to argue. And I guess, Mr. Tope, I would ask why wouldn't you be disqualified as counsel? I guess I'm going to start there.
That's fine, then, Your Honor.
First, because sorry about that.
What would
Why wouldn't you be disqualified as counsel in this case?
Here, Judge Simpson dives straight into the core issue. No sugarcoating. He's questioning whether the plaintiff's attorney, Ms. Tope, can ethically stay on the case. It's a high-stakes moment. If she's disqualified, her clients lose representation mid-litigation. Her response tries to sound airtight. Premature motion? No conflict? I'm not a party. But the problem runs deeper. Courts take potential conflicts just as seriously as actual ones. The rule is simple. If you might need to testify later, you probably shouldn't also be arguing the case. That's like being both a player and a referee in the same match. Judge Simpson isn't convinced, and viewers can sense the storm brewing. The key phrase, "Why wouldn't you be disqualified?" is not a question, it's an omen. Legal insight, motions like this test credibility. Once doubt enters the record, every argument after feels compromised. Audience question, do you think the judge should disqualify her now, or wait until trial to decide?
Your Honor, their counter complaint is this. Their complaint or their motion to disqualify me is premature. It's not right. There's no certainty that the cases will go to trial. The plaintiff's right to the legal representation of their choice would be irreparably damaged if their attorney, me, were not there to represent them during the preliminary steps before trial. If the case does go to trial, defendants can make the motion then. The defendants claim in their brief that there is a conflict of interest. A conflict of interest does not exist. I Donna K. Tope, MSJD, has no legal or personal relationship with the defendants in this case. Donna K. Tope, as plaintiff's property managed agent, has no legal or personal duty or legal relationship with the defendants of any kind. The legal brief is in error. Donna K. Tope, MSJD, me, the plaintiff's attorney, is not a party in any of the Cassidy's legal filings. Their counter complaint is against Alec Jerome, Caroline Jerome, Cambridge Family Holdings Property Management Company, and Donna K. Tope, the Jerome's property management agent. The complaint is a documents case. It is a landlord-tenant case for non-payment of rent and termination of the lease, and that the Cassidys violated several terms of the lease between landlord owners Jerome's and the Cassidys.
Okay, Mr. Let me stop you for a moment.
Mhm.
On some of that, you may be correct. But I think the biggest problem that I see, and there are a number of them, but the biggest problem I see is you representing in a case in which you may be a witness.
And there it is, the ethical dagger. Judge Simpson identifies the exact red flag. Ms. Tope isn't just representing the landlords. She's also directly involved in managing the property at the heart of the dispute. That means she could become a fact witness. In legal ethics, this is Rule 3.7 territory, the advocate witness rule. It forbids attorneys from acting as both lawyer and witness in the same case unless certain exceptions apply. Why? Because it confuses the jury and undermines fairness. Imagine a lawyer arguing passionately one moment, then taking the stand to testify the next. How do you cross-examine your own counsel? Simpson knows exactly how risky that is. His tone says, "You're too close to this." The moment he mentions problem, the courtroom freezes. You can hear professional reputation brushing up against the edge of discipline. What's fascinating is her denial. I'm not an essential witness. But ethics doesn't hinge on essential. It hinges on potential.
And my next point is directly on that point, and that is that the case is based on the Cassidys withholding all rent and utility payments beginning with those due September 1st. The defendant's defense is limited to the legal basis for the claim that those repairs were so egregious and made the home so unlivable so as to rise to remedy of withholding all rent beginning December 1st. There are 4 different witnesses. They have filed the case against Alec Jerome, Caroline Jerome, Cambridge Family Holdings, and Donna K. Tope. All 4 of those people could be witnesses for any of the evidence.
But counsel, that doesn't negate the fact that you could be a witness.
I'm not an essential witness. There are 3 other people.
But hold on. I think that you are, if what's contained in here is correct. And that is that you're having these conversations with the other parties.
I'm having these conversations. Could you be a little more specific?
Well, but you're arranging certain things. You're the one talking to them. You're the one dealing
As
with
the
them.
agent is okay.
Right. I get it. I get why you're doing it in that capacity. I don't
Right.
have any issue with
Okay,
that.
I'm just trying to understand
Right.
what
What I have an issue with are the rules of professional conduct, particularly, and then you representing a party where of rights, because of a conversation that might have ensued, you would be called as the witness. That's a problem.
Okay, the rules of professional conduct, and that is where I that is behind what I say, that the brief of a conflict of interest does not exist, is because that an attorney in a party to a suit cannot be a witness. I, Donna K. Tope, MSJD, am not a party to any lawsuit that they have filed.
No. But the rule also indicates you can't be the attorney and witness.
The other three parties are the best witnesses because they're the landlords.
But counsel, just by being here the number of times that we've been here, what's clear to me is that you're, just by way of example, you've got conversations or have conversations that you've had with the Cassidys directly, with Eric and Paula Cassidy.
Not as an attorney, only as the property management. And they are all related to property management.
But it almost would be better if you had it as the attorney, because that puts you in a different boat. It's precisely what you just said that causes the problem.
The tension spikes as the judge interrupts. Classic Simpson control. He's heard enough justifications. Ms. Tope insists she's only managing the property, not negotiating. But here's the twist. Those management conversations are legally dangerous. Any statements made while she acted as the property manager could later be used as evidence. So when Simpson says, "It's precisely what you just said that causes the problem," it's pure judicial precision. Her own words confirm his concern. This is a powerful moment of courtroom self-incrimination, not by guilt, but by admission of overlap. She's blurring her professional boundaries, and Simpson's dissecting it live. Audience reflection. Would you keep her as your lawyer after this? Or would you start Googling new counsel immediately? Behind the robe, the judge's job isn't just fairness. It's to protect the integrity of the legal process. And right now, that integrity is wobbling.
You are having these conversations, negotiating with them, imploring them, taking their complaint. Hey, hold on.
I'm not negotiating. I'm just managing the property.
Right. But in that management of the property, you're having the conversations with the tenants.
Through their attorneys, always. Now, once these cases began, I do everything through the attorneys as well.
They didn't always have attorneys.
No.
Right? You dealt with them directly.
Neither did the Jeromes.
Ms. Tope, I think, let me just be clear about this. I am loath when an attorney comes before the court to disqualify an attorney ever.
This is where Judge Simpson's judicial philosophy surfaces. He hates interfering in attorney-client relationships. His voice softens, not out of sympathy, but principle. The legal world is self-regulating, he reminds everyone. Lawyers should know when to step aside. But there's irony here. While he preaches restraint, the facts are boxing him in. The opposing counsel's motion isn't tactical, it's logical. The conflict of interest isn't speculative anymore, it's visible. Simpson's hesitation shows the balance every judge must strike, respecting professional autonomy while safeguarding ethical integrity. He doesn't want to disqualify her, but he's already rehearsing the reasoning in his head. This is the turning point where moral discomfort meets procedural duty. Engagement moment. Do you think the judge is being too lenient, or just giving a fair chance to explain?
I just am. I think attorneys, we're in a profession that is in a lot of ways self-governing. So if there is a conflict, I mean, if you just take the basic structure, you say that if I am an attorney in a case and I could be a witness to something in the case, then you almost have to rely upon the attorney not to enter into representation. Now, having said that, and so typically attorneys won't, right? And so I don't like, because I think attorneys have to make that decision a lot of times on their own, right? And so I don't like to get involved in that. But when it's brought before me that an attorney is going to be a witness in the case, and the other reason I don't like it is because sometimes that can be used from a tactical perspective from one side or the other. And so I went through this in great detail. And quite frankly, trying to find a way that would preserve your ability to represent these individuals. That's really how I approach it when I'm reading it, right? Because what I say to myself is, if an attorney isn't supposed to be in a case, the attorney's going to get out of the case. This other side's filing this to get this other attorney out of the case. So I'm going to operate on the presumption that the attorney should be there. When I finish reading this, and then also knowing and having been here and heard the case, I'll be absolutely honest with you. I don't think you can represent the parties in this case, because you are clearly, in my mind, going to be a witness.
That's the gavel drop moment. Judge Simpson officially voices what he's been building toward for 10 minutes. She's too entangled to stay on the case. The courtroom energy shifts from debate to inevitability. This statement carries real consequences. Once a judge declares a lawyer clearly going to be a witness, the path to disqualification is practically locked. The rest is just paperwork. It's also an insight into judicial restraint. Simpson waited, probed, tested her logic. But once the line is crossed, he acts decisively. The ethical rationale here is simple. Credibility of the court outweighs convenience for the parties. Allowing conflicted counsel could taint the entire proceeding. Notice how Ms. Taupe tries to pivot. Only if we go to trial. But ethics don't wait for trial. They protect the process from the start. You can feel the quiet sting of realization, her confidence cracking under judicial logic.
Now, I'll stop you, hold it before you say anything.
That's if we go to trial.
But here's what I don't want to end up in. But there can be certain points before trial. In the way I operate my cases, where I set them for a final settlement conference,
Right.
and the thing in certain
Yeah, no,
representation.
I would be acting as their attorney in those pre-trial.
Well, the problem is I may ask for certain representations from the parties, right? I don't want to.
I understand. I get exactly that. There is a problem there because you would be talking with them from, I get that.
And I don't want to be, so the interesting thing about all lawyers are bound by this, that if I see a violation of the ethical rule,
Yeah,
I'm then,
that would be.
hold on, I'm then required to report.
Okay.
So I do not want to be in a position where I have to report you.
This is the moral climax of the hearing. When a judge says, "I don't want to report you," it's not a threat. It's a warning wrapped in mercy. Judge Simpson is invoking Rule 8.3, the professional duty to report ethical violations. If he sees a breach and ignores it, he becomes part of the problem. The gravity of that line is immense. Ms. Taupe realizes this isn't just about losing a case. It's about professional survival. A judicial report could mean investigation, sanctions, or worse. The irony? The judge's compassion is saving her from herself. He's giving her a path to step back voluntarily before the system forces his hand. That's why his tone is calm yet final, a masterclass in judicial balance, discipline tempered with decency. If you were the judge, would you report her immediately or give her this one warning?
I don't do that unless I absolutely
Oh, well,
have to. And
thank you very
I
much.
don't want to do that. I wouldn't want to do it to anyone.
So can I just want to suggest that those kinds of, your kinds of reservations, your kinds of concerns would not apply if the Jeromes were representing themselves. And yet they still are going to be witnesses in their counter complaint.
That is absolutely correct.
Okay,
It wouldn't apply to them.
no,
It doesn't.
no, because they're not attorneys under the attorney. Well, I still say that I would like you to wait until we actually come to that Waterloo. But I know that because we may not. I mean, we were hoping that we could get some kind of meeting of the minds at this discussion that occurred without attorneys.
This is the what-if phase of every courtroom drama. The moment when a party tries to downplay the conflict as something that could still be fixed with diplomacy. Ms. Taupe clings to the idea of a settlement, perhaps hoping a resolution will erase the ethical problem hovering over her. But Judge Simpson isn't buying it. His patience is procedural, not personal. He knows that even if peace talks succeed, ethics violations don't disappear. Her tone sounds optimistic, but it's more like a survival tactic, the lawyer's version of stalling for time. In real terms, she's already standing on quicksand. A meeting at the University of Michigan's Dispute Resolution Center might soothe emotions, but it can't rewrite professional conduct codes. What's interesting here is Simpson's restraint. He doesn't crush her attempt. He lets her talk herself into understanding the trap she's in. Question for viewers. Do you think the judge should cut her off right here or let her realize it herself?
At the University of Michigan's legal department's dispute resolution meeting that took place, and we did not. But if a settlement does occur before I have to come in a legal court proceeding representing the Jeromes, then I wouldn't have to disqualify myself from advising them.
Taupe, I'm going to have, I've been doing this a minute.
Yeah,
And I'm just going to tell you, I'm going to see it on motions. I'm going to see that
got it,
this issue get raised.
got it.
The moment an affidavit's filed.
Yeah,
We're going to have a problem,
yeah.
right?
I totally am understanding your issue.
And so I don't want, everybody has a right to have their cases heard expeditiously to get through them. And I just don't think that can happen in this case.
Given what's going on.
Representing them. Because and here's the other part. The other part is this is a summary proceeding and maybe one of the thickest or second thickest I've had this year filed. But summary proceedings operate at a different pace. We operate rather quickly. The moment they file a motion, file an affidavit alleging that you said we got a problem.
Yeah,
And then I have to put it on hold, which is not, quite frankly, in your client's interest. I have to put it on hold, waiting for an attorney to come in to just answer the motion, let alone argue.
This is the practical fallout Judge Simpson has been hinting at. He's explaining, step by step, why the ethical tangle isn't just theoretical, it's procedural poison. If Ms. Tupp continues, the court would have to freeze proceedings every time her role as both manager and attorney collides. In landlord-tenant law, speed is everything. Summary proceedings are supposed to move fast, yet this case is already bogged down by thick filings and ethical fog. The judge's frustration leaks through his calm delivery. This case was meant to be simple: rent not paid, lease violated, determine remedies. Instead, it's turned into a professional ethics exam. When Taupe admits she understands like an arrow to the heart, it's one of the rare raw emotional moments. She finally accepts the gravity. The courtroom tension drops slightly, not from relief, but resignation. It's a reminder that in law, logic always catches up.
Okay.
Because you would place yourself in a quandary by even trying to answer.
No.
You follow me?
No, absolutely.
Okay.
Absolutely. I mean, like an arrow to the heart.
Okay. Well, don't put it that way.
No,
It's kinda-
I just got to say,
Yeah.
that's what it feels like, but
Okay.
I totally understand.
All right. So I guess my question is, if you, rather than me even ruling on this motion at this time, but if you were, how long would it take for you to find counsel to substitute in?
I will talk with my clients and we will have a speedy discussion because they are on it. And I can get back to you within several days.
Okay. Hey, well, as this side to the Jeromes, do you, based upon the discussion, I realize you guys aren't lawyers, so did you have any questions with anything that the court was saying or anything that was going on there?
Alec, did you want to? I think it's clear. I think I understand what you've said. Thank you, Judge Simpson. And yeah, we can confer and we'll figure it out. You know, there is always a lawyer present just because of the nature of the tenants, but we'll find another lawyer that will work and won't cause a conflict. I understand that's super important.
That line is the turning point for the plaintiffs. Calm, rational, and perfectly timed. Alec Jerome understands what many litigants don't. Sometimes protecting your case means cutting ties. His acknowledgement diffuses the tension that's been building since the hearing began. The judge's nod confirms it. This is what he wanted all along: voluntary compliance, not judicial enforcement. From an analytical perspective, Alec's statement restores credibility to his side. By showing respect for the process, he's protecting the strength of his argument going forward. The jury, if one ever hears this case, will never see this part, but it matters. Optics in court extend beyond the record. They build reputation. This is also a rare moment of clarity in the fog. Everyone, for a brief second, agrees on something. In a courtroom that's been pulsing with tension, that's powerful.
Yes. Okay. So, yes, ma'am.
You did understand what she said, that in every situation involving the tenants, there is a lawyer present on their side because Eric is a lawyer and he has sort of,
Right. And if
he's
And-
inserted lawyerly things into the discussion.
I get it. But
Okay.
if Eric, but if he were representing, quite frankly, he might have a problem if he were to step in and represent even his wife in this. He could certainly represent himself. I mean, that's he could do that, but that's not what this is.
Yeah.
Right. And I get there's always a lawyer involved. Sometimes you throw a stone, there's a lawyer involved. So
Mr. Cassidy is licensed in the state of Texas, not in the state of Michigan.
state of Texas, my condolences. All right. So, that's it. So I guess, my thought process is, is to adjourn this out a couple weeks, allow them to substitute an attorney in even before I rule, so that way we're not even trying to do things right now that may cause problems later. But I don't know how you feel about that. We like having you here every couple of weeks or so, but
Your Honor, I mean, we really are asking the court to make the decision today, and I think an email that we received last night from Ms. Tope at like 11:30 p.m., coupled with the motion that she filed a few days ago to allow the landlords to repair the property without the tenant's presence, show how integral she is and what a fact witness she is. She's, in our opinion, the only fact witness. We don't need anybody else.
Eric Cassidy delivers the knockout argument that seals Ms. Tope's fate. She's not just involved, she's the centerpiece of their counterclaims. When the opposing side labels you the only fact witness, your credibility as an attorney disintegrates instantly. Cassidy's phrasing is sharp, almost surgical. He doesn't attack personally, he dissects legally. Every word builds the case that her presence in this courtroom compromises fairness. Simpson's body language says it all. He's already decided. The integrity of the process outweighs any personal skill Ms. Tope brings. The defense has handed him the final justification he needs. What's remarkable here is the restraint. No shouting, no outbursts, just the quiet finality of legal logic closing a loop. Question to viewers. If your lawyer suddenly became the main witness against the other side, would you still trust their judgment?
Not to mention the fact that most of our counterclaims are against her individually.
Oh, I know.
Emotional distress and whatnot that we're going to file is against her.
I know.
Individually. And she has a clear conflict of interest because I presume the Jeromes are going to distance themselves from her and say they haven't authorized the behavior that she's been doing on entering onto their property.
And those are all allegations.
I know. And look, folks. All right. Maybe my problem with being a judge is I'm a lawyer's judge.
Is what?
I'm a lawyer's judge. I love the practice of law and I like watching lawyers practice. And where I don't have to enter into having lawyers do the right thing or whatever, and I don't. I think you had Ms. Tope a certain position that she had. We had that brief interaction we just had now. My understanding is that there will be an attorney substituting in. So what I'm going to do is, this is how I'm going to leave it, because I do understand your point, but you have 7 days to file a substitution of attorney. If not, the court will enter an order granting the disqualification of this. Just do it that way. All right. You're welcome. And I'm not going to proceed on anything else until I have different counsel on this side.
Okay, so they would have to refile my motion that to have the tenants vacate while the landlords do.
No, I mean, I'm not going to require them necessarily to refile. They're going to have to sign something for that motion under the court rules because it has to be their motion.
Okay.
They don't have to absolutely refile it. I'm not.
Excellent.
I mean, there are ways around that notion without causing undue delay.
Yeah.
All right.
Thank you.
So what I will do, and if counsel, if you would prepare the order that there will be a substitution, right?
Yep.
Or that the court will be granting that. So that order needs to be prepared, submitted to the court. I will adjourn this out 2 weeks. And
Judge,
we will come back. And I'm sorry. Yes, ma'am.
I'm being a little sister. My brother has had his hand raised because he did want to also.
I'm sorry.
That's okay.
I'm sorry. I wasn't looking at that screen.
That's totally cool. Totally cool. Okay.
All right.
Alex.
So you said you were being a little sister when you did that?
Speaking up for my
I
brother.
wasn't speaking up. I did have my
You
hand
know,
raised.
no, it's okay. I have one of those, and you're right. I get him. Big brothers were just quiet until our little sister says, "Gotta say something."
Okay, I'm back.
Go ahead, sir.
Your Honor, the only point of question that I had was related to, we actually came today prepared to make an offer for settlement of the situation related to the payment of all of the back rent, penalties and fees, but absolving the Cassidys of any of the penalty related to the forfeiture or breaking of the lease, which was in the neighborhood of, I believe, $26,000. Does that make a difference in terms of having a discussion or not?
Yeah, no,
That's that the record be stricken on this in terms of any proposed settlement that we have.
yeah, in the court, its head is not, I'm not even dealing with that. The short part of that is you came to try to look to negotiate it. What I'm going to suggest to you is just hold it for a minute in terms of what position you may want to put forth. Let's get other counsel in to do that who can also look at it. And then if that's still your proposal, certainly there'll be time to submit that to the other side.
Yes.
All right,
Okay.
thank you.
We're heard. Alec, you were heard.
All right? Yes. Okay, so what I'm going to do then is I will adjourn this to July 26th. I set it at 9. You will get a time breakdown as to when it'll be set. It's likely gonna, well, no, what time will it?
3 p.m.
Oh, it will be set, thank you. At 3 p.m. All right, on the 26th,
July 26th.
3 p.m.
Thank you.
All right, folks. Thank you.
Thank you, Your Honor.
Thank you.
And that's the closing bell of this courtroom confrontation. Judge Simpson adjourns the case, giving everyone time to regroup before the next chapter. But make no mistake, this wasn't just about landlord versus tenant. This was about professional boundaries, credibility, and the thin ethical line lawyers must never cross. The ruling here underscores a timeless legal truth. Even good intentions can't outweigh ethical conflicts. Ms. Tope's passion for her clients was undeniable, but passion without distance becomes liability. For the Jeromes, this pause is a second chance to re-strategize and bring in counsel unclouded by personal ties. For the Cassidys, it's validation that ethics still have teeth in modern litigation. And for Judge Simpson, this hearing cements his reputation as firm but fair, a lawyer's judge who protects the integrity of the court above all else. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.